against Royal Bankers Coffee.
Yes.
Well, may it please my Lord Deputy President and my Lords, I appeal on behalf of the appellants, Ms Smith and Mr Burrell, my learned friend Mr Butters and my learned friends Mr Taylor of King's Counsel and Mr Robertson, appear on behalf of the Respondent Bank. As your Lordships can see from the Statement of Facts and Issues, page 76, and can I invite you to go to that, please? I should say, my Lord, that the numbering works, by which I mean, if you are purely electronic, it's simply electronic page 76. If you're choosing to take advantage of the key documents, you simply go to the pagination on the right-hand side of the page at the bottom.
Yes.
And that way it's one page fits all.
That doesn't always happen.
No.
But in this case,
No, I was pleased.
In this case, it does.
Last time, when it worked, I had the approval of none less than Lord Reed, and I'm sticking to that system, and it seems to be effective.
It works fine. Thank you.
So your Lordships can see from page 76, paragraph 50, that there are 4 issues. In terms of the order in which I propose to take them, I'm going to take the first issue first. The third issue, as you can see from our case, the references paragraphs 70 to 72 of our case, flows into the first issue, or flows from the first issue, so that will come as part of the first issue. And then I'm going to take the second issue and then the fourth issue. And for the avoidance of any doubt, in our respectful submission, the second and fourth issues can be dealt with in fairly short fashion if and once we've gone through the first issue, which is the heart of the appeal. As far as concerns the first issue, namely whether the Court of Appeal was wrong to find that the unfairness in the relationships ended in 2006/2008, and for these purposes, as per in the Court of Appeal, with your Lordship's approval, I will probably focus on the case of Ms Smith, and so I may not always mention 2 sets of dates. The Ms Smith dates that are relevant to 2006 is when both the PPI agreement ended and the last payments were made, specifically in relation to the PPI payment, and 2015, which is when the credit agreement came to an end. So that being the issue, can I take that in 2 parts as follows? The first is how the scheme, in our respectful submission, established by sections 140A to C, operates. And the second is where, respectfully, the Court of Appeal went wrong. So far as concerns how the scheme established by sections 140A to C operates, I have 5 submissions to make, which I'll seek to develop in turn. The first is the new scheme was designed to enhance consumer protection. Secondly, the proper interpretation of the right of action provided by the new scheme is assessed against the backdrop of that statutory purpose, enhancing consumer protection, and not having regard to the Limitation Act 1980. So the proper interpretation of the right of action has regard to the statutory purpose, but not the Limitation Act. Third, fourth and fifth I'm going to separate out, but when I make my submissions I will bring them together because they're so heavily interrelated. But there are effectively 3 more submissions. Thirdly, the scheme invites a single assessment of unfairness in a singular relationship. A single assessment of unfairness in a singular relationship. Fourthly, the single assessment is to be made at the date of trial or where the relationship has ended at the date the relationship ends. Fifthly, the assessment of unfairness requires the court to have regard to the whole of the relationship. The assessment of unfairness requires the court to have regard to the whole of the relationship. My Lord, can I start with the first? The first is not, I believe, in issue. That is that the new scheme was designed to enhance consumer protection, to which end can I invite you to the Court of Appeal judgment at page 167, paragraph 42. So para 42, page 167. It's tab 7, my Lord.
It's the last couple of lines on that page.
My Lord, it's the last couple of lines on that page, having been, if you like, set up by the references before.
Yes, indeed.
And the setup in the references before includes, as this case does, three of the justices present today, and who I shall refer to, if it's hoping that I've got the appropriate system, I'm afraid back to as Mr. Leggett rather than as my Lord Leggett, because at the time Mr. Leggett was Mr. Leggett. I hope that's the right way in which to deal with matters. And here we have references to my Lord Justice Briggs and Lord Justice Kitchen. Can I, in addition, just note that whereas the Court of Appeal have referenced Lord Sumption in Plevin at para 10, can we just dip into Plevin, please, for two other references in Plevin. So Plevin is, for these purposes, it's at page 536. I don't think anyone is using hard copy for these purposes, of which would be
We don't have hard copies.
That's right, you only have the key documents.
That's right.
Well, I've got my own hard copies, but you've got one or two documents, so you could ignore that.
It's not understanding you can have the key documents.
Well, I mean, brownie points surely goes to Lord Briggs. I can say no more than that.
Lord Briggs is as Lord Kerr was. The
electronic
spearhead of the
Briggs report,
electronic papers,
I recall, onwards. In the Plevin judgment of the Supreme Court, if the court kindly goes to page 536, paragraph 7, this is effectively reconfirming what Lord Justice Briggs had said in the Court of Appeal. You'll see down H, the new provisions replace the provisions which have conferred a limited power to reopen extortionate bargains, but set too high a bar to debtors and sureties wishing to challenge the terms of their agreement. And if you can then go on to para 29, which you'll find for these purposes at 545, so right at the top at A, where Lord Sumption says, these seem to me to be very clear. Section 148 was undoubtedly intended to introduce a broad definition of unfairness in place of the narrowly framed provisions which had previously governed extortionate credit bargains. It's of a piece, if I can put it that way, with the clear intention of Parliament, which is to improve matters from the perspective of the consumer.
Beg your pardon, I missed the paragraph number.
My Lord, yes, it's paragraph 29, and it's at page 545 at A.
Yeah, thank you.
My second submission was the proper interpretation of the new regime is made against the backdrop of this statutory purpose, namely enhancing consumer protection, and not against the backdrop of the Limitation Act. And I make this submission because the respondent's case is that the appeal is primarily about Section 9 of the Limitation Act. And again, for these purposes, can I go to the respondent's case, please? So this is page 109. Paragraph 7. So page 109, paragraph 7. So in the middle, you'll see in the middle of paragraph 7, this case is primarily about limitation under Section 9 of the Limitation Act. And that is then developed, if you kindly go on to page 116, into what's a sort of pillar of the respondent's case. Because if you go then to paragraph 34, please. I hope I'm not going too fast. It's page 116, paragraph 34. Does your Lordship have that?
Yeah.
The appellant's construction of Section 148C is contrary to the general policy that statutes should be interpreted so as to be consistent with the general policy of the Limitation Act. And then over at paragraph 37 on page 117, you'll see the statutory purpose is to provide enhanced consumer protection. This is uncontroversial, but it certainly doesn't follow that this purpose overrides the purpose of the Limitation Act. That's how the case is put against me. And the correct analysis in our respectful submission is as follows. The court's first task is to construe the statutory scheme so as to determine the constituent parts of the legal right of action provided. So that's its first task, construing a statutory scheme to determine the constituent parts of the legal right provided. And that exercise is wholly unaffected by limitation, purpose or policy. So, for instance, you won't find embedded on statutory interpretation some principle of statutory interpretation that says be careful when you have a look at a new statute that's got a cause of action or right of action, because we've got confusion arising out of the twin uses of those expressions in this case, which I'll develop. Inviting the court to construe the meaning of a statute, it's not the Limitation Act, but another statute that provides a legal right of action so as to be consistent with the general policy of limitation. No such thing exists. And it doesn't exist for a reason. Limitation Act offences are procedural. The defendant has to plead it. And as Lord Justice Diplock said in the Tang and Cooper, and can I take you to this quote? This is page 502. In the Tang and Cooper. Down at the bottom at G, right at the bottom, so 502G, the Act is a Limitation Act. It relates only to procedure. It does not divest any person of rights recognised by law. It limits the period within which a person can obtain a remedy from the courts for infringement of them. In other words, you have to construe the statute to work out what those rights are before you come to a procedural defence called limitation. One is logically prior to the other. And the confusion arises because of the use of the word cause of action. Cause of action can mean at least two things which are different. One is cause of action for limitation purposes. That is essentially the facts that go to establishing your claim. The other is right of action, and that's what we're focusing on at this stage, the legal right of action, which is sometimes referred to as the cause of action. When you ask someone, what cause of action are you claiming in, you might say, I'm claiming in negligence. Or I'm claiming for section 140A to C. But to avoid any confusion, we can call that a legal right of action. And that's the stage at which we're at this stage. And whilst on this point, I would note that the respondent also says at paragraph 11, all part of quite a lengthy passage in relation to the importance of limitation in this case, that's page 110, since at least 1623, Parliament's limited the time in which claimants may bring their claims, and there can be few more long-standing legislative interventions in the field of civil justice. Well, I can name one, because if you go to the provision which has been referenced there, it's the Limitation Act, and on the following page is the law against usury, which you'll see at page 641. If you go to page 641, you see the Act for Limitation of Actions that my learned friend refers to in 1623 to 24. And if you go over the page, you'll see an Act against usury, in which any interest rate of 8% is void. That, of course, was not Parliament's first intervention in the field of usury. There were previous statutes in relation to usury, and per a case, should there be those interested in legal antiquity, called Lloyd, Keatam and Williams, it apparently goes all the way back to the laws of King Alfred in 871. The provision was made in respect of limiting money lending in its deemed evil effect. And we see from Lord Nichols, when you go all the way through to Wilson and First County Trust, if you can just dip into page 1444,
Is it 1444?
1444, my lord. Paragraph 75. This is the case in which there was a human rights challenge to section 1273 that says if you don't get your procedure right, you can't enforce your credit agreement, which digressed into issues of looking at Hansard for the purposes of interpretation of the Human Rights Act, etc., but that's a different issue. But paragraph 75 at the bottom, nor do I have any difficulty in accepting that money lending transactions as a class give rise to significant social problems. Bargaining power lies with the lender, and the social evils flowing from this are notorious, etc. So if the reason I digress into that is the court need not be surprised or concerned that Parliament has established a new scheme in the 21st century, following a long history of intervention, which for the reasons we give in our case, or under which, for the reasons we give in our case, limitation does not run during the currency of the credit agreement. Set against the context of long-standing intervention and the social policy concerns, none of that should come as a particular surprise. Can I then turn to my next three submissions, which, as I've already indicated, are heavily linked? And can I start with the wording of section 140A? And for that, can you kindly go, please, to page 379? Actually, 377, sorry. 377. So this is section 140A, and I'm going to break this down into parts. Of course, the whole thing has to be read as one piece, but I'm just, for these purposes, going to break it into constituent parts. The first part to note is right at the beginning. The court may make an order under section 140B in connection with the credit agreement if, etc. And so there is the linkage, if you then go over to 379, to the powers of the court in relation to unfair relationships under section 140B. An order under this section in connection with a credit agreement may do one or more of the following. By this straightforward mechanism, Parliament has, in our respectful submission, provided a right under section 140A and a remedy, brackets, albeit discretionary, under section 140B. The respondent, I would note in passing, disagrees with this analysis. If you go to page 118, paragraph 41, so page 118, paragraph 41, the respondent says it's right to say the remedy under section 140B should reflect the unfairness found under 140A, but it's incorrect to say section 140A provides the right and 140B the remedy. This is because a cause of action includes all the facts necessary to establish the judgment sought. And that, in our respectful submission, is to return to the confusion between cause of action for the purposes of limitation, which is facts, and what I'm talking about, which is legal right of action. The right of action is provided by section 140A, the remedy by section 140B. The second thing to note is that whatever the remedy sought, and by whomsoever it is sought, including, for instance, by a surety, the gateway to any such remedy is section 140A. So if you turn over to 379 to 140B, you'll see, for instance, if you go to 140B1A, that you can require an associate or former associate of a creditor to make a payment, or under B to do something or not do something. And you can also see that you can, under 140BD, direct the return to a surety. So you get remedies for a surety. Whatever the position under 140B, no one gets started under 140B unless they get through the gateway of 140A. That's clear from the right that's set out. And the gateway under 140A is very specific. It's not about sureties, it's not about associates, it's about the debtor-creditor relationship as I'm going to develop. So going back to 140A, which is on page 377, the right of action is based upon the relationship between creditor and debtor. See the language. The court may make an order under section 140B in connection with the credit agreement if it determines that the relationship between the creditor and the debtor, and obviously it carries on, I'm going to deal with it all, but just pausing at that point. So that is what the right of action is based upon. It is not based upon the credit agreement. It's not like an extortionate credit bargain, which is based upon the bargain. It's not based upon acts or omissions of the creditor. It is based upon the relationship, singular, between debtor and creditor, not surety, debtor and creditor. And then carrying on with the statutory language, which arises out of the agreement, that is a reference, it's agreed to credit agreement, the credit agreement, arising out of the, so I would say, credit agreement, or the credit agreement taken with any related agreement. And related agreement is defined, if you kindly go to page 382, you're in 140C4. I hope I'm not going too fast, my Lord. At 140C4, references in section 140A and B to an agreement related to a credit agreement are, and then you've got A, B, and C, and you'll see A is a credit agreement consolidated by the main agreement, and B is a linked transaction. Now, it's common ground that the PPI agreement in this case is a linked transaction. But can I just go through, because I'm going to return to this point, how it also includes a credit agreement consolidated by the main agreement. If you then go over the page to 383, at little 7, so 140C7, for the purposes of this section, a credit agreement, the early agreement, is consolidated by another credit agreement, the later agreement, if the later agreement is entered into by the debtor, for purposes connected with debts owed by virtue of the early agreement, and at any time prior to the later agreement entered into, the parties to the early agreement included the debtor and the creditor. So much as you'd expect by the term consolidation. Now, the significance of this can be seen from the working example that's provided by the case of Patel, the facts of which I don't propose to rehearse, because I'm going to assume, if I may, that Patel has been considered in advance by this court, because it's obviously such an important judgment, in which the West loan, circa 1982, and the Londis loan at the same sort of time were both consolidated into the 1992 loan and recognised by Mr. Leggett of Queen's Counsel to have been related agreements. And you'll see that reference if you kindly go to page 525. So 525. Top of the page, it's the end of paragraph 67. The history includes not only the 1992 agreement, but also the earlier loan agreements, which are related agreements within the meanings of section 140C 4 and 7, because consolidated by the 1992 agreement, which is, in our respectful submission, entirely accurate. And that meant, as we later see, that Mr. Leggett had regard to the fairness of those related agreements. He considered they were not unfair, but he had regard to them. And he had regard to them because they were related agreements within terms of section 140C. And so returning to page 377, under section 140A, which is unaffected, its language by the transitional provisions, I'll come to them later, but it's unaffected, requires the court, it says the court may make an order under section 140B in connection with the credit agreement if it determines the relationship between the creditor and debtor arising out of the credit agreement or the agreement taken with any related agreement. So that the ordinary way in which this statutory provision works invites the court to go back as far as the agreement that's subsequently been consolidated, what the statute calls the earlier agreements, before you even get to this agreement. That's all to be had regard to under the clear and express terms of section 140A(1). And the right of action is engaged if the court makes a finding that the relationship between debtor and creditor arising out of, and I'm just going to say the credit agreement rather than repeatedly and or the credit agreement taken with the related agreement, but it's all there, is unfair to the debtor. And that again is me simply tracking the language of the statute, doing no more than that. And as Mr. Leggett observed in Patel, and here it's paragraph 64, and again, can I go back, and Fred, I make no apologies for returning to the Patel case, page 524, paragraph 64, B, as I construe section 140A, the question whether the relationship between a creditor and a debtor is unfair to the debtor, as I construe, the question whether the relationship between the creditor and debtor is unfair to the debtor upon the single answer to which the power to make an order under section 140B depends, is a single question which admits of a yes or no answer that has to be determined at a particular point in time. That respectfully must be right, because you can read it in no other way. The court is saying, is the relationship unfair? That's only a yes or no. You don't get degrees of unfairness. It's unfair or it's not unfair. There may be reasons why it's unfair, but the logically prior question is it unfair? And it's binary. And then can I focus in on the use of the word is in section 140A(1), and that's the relationship between creditor and debtor arising out of the agreement is unfair to the debtor. Parliament is directing attention to the current relationship. Pausing there, the use of the word relationship is apt in the context of a credit agreement, because a credit agreement by its nature involves the debtor paying off credit afforded to him over time. That is what credit is all about. It's not like an ordinary purchase of some sweets in a shop. Simple sale of goods. It is by definition going to involve a relationship, because it's going to involve a time period over which they are in relationship. And the Court of Appeal below put it in this way, paragraph 54, which is at page 171. Page 171. Paragraph 54, about 5 lines down, a relationship is something which continues over time, with which we respectfully agree. So it is not a moot point as to when, during the course of an ongoing relationship, the court's charged with determining unfairness. Parliament has spoken and set that time in the present by using the word is. And consistently with this, where the relationship is ongoing at trial, the fairness of the relationship should be assessed as at the date of the trial, because that's the is being applied logically to an ongoing relationship. And given that Parliament has homed in on the current relationship, it makes entire sense that Parliament should choose to provide by section 140A(4), and for these purposes back to 377 please. So that's section 140A, and if down at the bottom on page 377 you will see a determination may be made under this section in relation to a relationship, notwithstanding that the relationship may have ended. And in this way, Parliament has removed any doubt as to whether a right of action which is focused on the present relationship dies with the termination of the relationship. It does not. But logically, that means that the date to be selected should be the last date of the relationship, because that is the closest it is that we get when the relationship has ended. And such an analysis is consistent with the other requirements under section 140A, which I'm going to now go through, and then I'm going to draw that thread together by going back to why this interpretation or construction of section 140A fits with what I'm about to set out. So I'll come back to it once I've gone through what the other parts are. So can I start with the remainder of section 140A1, which provides that the unfairness must be because of, so your lordships can see, is unfair to the debtor because of, and I'll just leave it as ... for the moment. In other words, causally linked to one or more of the matters set out at A to C. And for these purposes, can I ask the court to note the following? The matters set out in A to C extend over the whole range of the relationship. And that's express, because your lordships can see, not only have we got the terms of the agreement, we've got enforcement under B, which is something you'd expect close in time to when a claim has been brought, but you've also got under C, any other thing done or not done by or on behalf of the creditor, brackets, either before or after the making of the agreement or any related agreement. So including before even the making of the related agreement, which could be the earlier agreement subsequently consolidated. So that the scheme plainly anticipates that when the court undertakes its current exercise in assessing whether the relationship is unfair, it will be having regard to matters over a very long time frame vis-à-vis the relationship, going back indeed to prior to the credit agreement and prior to any earlier credit agreement subsequently consolidated. And just to see how clear Parliament is on that, can we briefly dip into the transitional provisions? And this is page 391.
Just before you do,
Yes, my lord.
am I right in reading 140A1C as therefore meaning before the commencement of the relationship?
I don't think so, my lord. It's an interest.
Why I ask.
Sorry, my lord.
Because it has to be a relationship that arises out of the agreement or any related agreement. So that when you get to C, before the making of the agreement or any related agreement appears therefore to contemplate necessarily a period before the relationship has started if you read it with one.
My lord, I'm personally undecided as to the because it could be said that when take the classic case of Scotland and the misrepresentation made by the double glazing salesmen, who are for these purposes agents of the creditor. So it could be said your relationship starts as soon as those double glazing salesmen attend.
I can see it could.
Yes, but
My
I don't think
is whether it does under this framework.
Yes, ultimately, I don't think anything turns on it. Is the position that I adopt in relation to that? It is an interesting question, in which it depends on how you choose to see relationship. Because certainly, one part of the analysis, and I was no longer going to make any of these submissions. I think I needed to get into this sort of world. But if you do break it up in the way that the respondent says, you can end up with a slightly mad world where you get an event occurring before the credit agreement, but you can't sue unless there's a credit agreement, and they're saying the event triggers your cause of action, then it's triggered before you've even got into a relationship. But you can go down a lot of rabbit holes in terms of analysis like that, which may not be particularly helpful. I don't think it particularly matters. Page 391, para 16.1 of Schedule 3 to the 2006 Act, which is dealing with transitional provisions, provides in terms, so it's page 391, my lords, it is immaterial, which is a very strong word to use, immaterial for the purposes of section 140C 4A to C, which I've taken the court to already and deals with, amongst other things, consolidated agreements, but it's all about related agreements, of the 1974 Act, when, as the case may be, a credit agreement or a linked transaction was made or a security was provided. And that's not a reference to the credit agreement, that's a reference to the earlier credit agreement. You see that if you go back to 140C at page 382. So 140C 4A. You see, it says references in 140A to C to an agreement related to a credit agreement, or references to a credit agreement consolidated by the main agreement, a linked transaction, and a security. And that's been tracked at para 16.1 when it says a credit agreement, a linked transaction, or a security. So that's a reference to what's called the earlier agreement, when the earlier agreement's been consolidated by the later one. So Parliament has actually said during the transitional period, or within the part of the Act dealing with transition, it's actually said, we don't care when your earlier agreement was even made. It could be your 1982 Londis and West loan. It can be even earlier. It is immaterial. It does not matter. And
the very remoteness may matter on the unfairness assessment, may it not? But all this is saying is that you can't say it's irrelevant merely because it's
absolutely
prior to the passing of the Act.
Absolutely. I'm concerned here with the right of action and how it works. In other words, what it is that the court is entitled, as a matter of law, required indeed, to have regard to, and it may make its assessment. This is ancient, and it has two options when something falls into that category. One option, which is difficult, and I make no express concessions in relation to this, which is to say it's so old I'm not going to find it's unfair. The other is to say the remedy is discretionary and I choose not to exercise it in the debtor's favour, which to me is a much more attractive logical premise to adopt, because it becomes extremely complicated, and I'm going to develop my submission in relation to why the relationship remained unfair in 2015, extremely complicated to explain to yourself how you've made a finding that an unfair relationship back in the day is no longer unfair.
And you're going to come back to that?
Absolutely. So the next thing I wish the court to note, please, based upon section 140A1, going back to the because of, is it says because of one or more of the following. In other words, Parliament expressly provides the court may have regard to more than one of the factors under A to C. In other words, the court may well be addressing the singular question whether there is unfairness, having regard to more than one matter, whether matters are spread potentially across a very lengthy period. That's all part of an entirely straightforward reading of section 140A. It's unavoidable. Next, can I then turn to section 140A2? So we're still on page 377. In deciding whether to make a determination under this section, the court shall have regard to all matters it thinks relevant, including matters relating to the creditor and matters relating to the debtor. And here again, can I go back to Patel and to paragraph 64, which is at page 524. So page 524. Paragraph 64, at the top at A, in which Mr. Leggett, having referenced section 140A2, which provides the court shall have regard to all matters it thinks relevant, my emphasis, impliedly without limitation in time, with which we respectfully agree or we adopt. That again, it has to be right, because there is no limitation. This is a must, not a may, shall have regard to all matters it thinks relevant, set against the backdrop where the causally critical factors themselves extend over this very long period, whether it predates the relationship, see the observation of Lord Briggs, or does not predate the relationship because the relationship kicks off as soon as something like a pre-contractual misrepresentation occurs. In other words, the court has to have regard to the whole relationship to determine whether the relationship now is unfair. And if you have a finger still on page 524 metaphorically, for me literally, but if you still are in Patel, if you can kindly go back to page 524, para 64, see the remainder of the analysis in that paragraph of Mr. Leggett ending at C. There is no possibility, therefore, if the court's entitled to make the determination of fairness at all, and is not barred by limitation from doing so, of restricting the temporal scope of the inquiry. And can I make two further references? The first is my Lord Justice Kitchen in Scotland. This is page 582, paragraph 78. My Lord, you'll tell me if I'm moving with too much enthusiasm. But hopefully the court's tracking this. So it's page 582, paragraph 78, right in the middle between G and H. In this regard, it's important to have in mind that the court must consider the whole relationship between creditor and debtor arising out of the credit agreement, and whether it is unfair, having regard to one or more of the three matters set out in section 140A(1). And then if you see over the page, at page 583, paragraph 82, this is where the Court of Appeal endorses the analysis of Mr. Leggett at paragraph 64. And in the lead-up to endorsing paragraph 64 at F, so we're para 82F, my Lord Justice Kitchen says, the focus of the inquiry is therefore the relationship between the parties, and if, as here, it's a relationship which continues to subsist, then the court must have regard to all matters it considers relevant, even if some of them occurred more than 12 years before the date of the claim. And can I also refer, please, to Plevin in the Supreme Court, Judgment of Lord Sumption. This is page 542.
I'm sorry, could you give me that page number?
Yes, my Lord, it's page 542. In the Judgment of Lord Sumption in Plevin, we're at paragraph 19. Paragraph 19 is the paragraph in which Lord Sumption explains that you can have an omission in relation to the fact and or amount of a very substantial commission, which triggers liability, triggers unfairness under section 140A. And in explaining how that system works at B, you'll see that Lord Sumption says, I'm going to sort of pick it up between A and B, as responsible for an omission making his relationship with the debtor unfair if he fails to take such steps as 1, it'd be reasonable to expect the creditor or someone acting on his behalf to take in the interest of fairness, and 2, would have removed the source of that unfairness or mitigated its consequences so that the relationship as a whole can no longer be regarded as unfair. Is how he's put it there. And now to draw that thread together that I indicated I would wish to do, having set out the remainder of the relevant parts of section 140A, the fact that the court has to have regard to the whole relationship reinforces that the only time at which the court can make its assessment on the issue of unfairness is at trial, or where the relationship's ended at the end of the relationship. If you make the assessment at any earlier point in time, then you are not, as the court, permitted to have regard to the whole of the relationship because you're stopping the clock. If you stop it in 2006, 2008 or whenever, you are not having regard to that which has continued in the relationship beyond that time. So the fact you have to have regard to the whole of the relationship is entirely of a piece with Parliament's injunction on the court to determine whether the relationship is unfair.
But Lord Sumption is, if you turn his example round, he's talking about a failure to take steps.
He is, my lord.
But if you think about those steps as being taken, and steps which would therefore have removed the source of that unfairness, or mitigate its consequences, so that the relationship as a whole can no longer be regarded as unfair, he's clearly contemplating a relationship that can change from an unfair one to a fair one.
Yes, my lord. And so do we. And we were open with the Court of Appeal in relation to that. It was respectfully, the submission I made on that has been misconstrued by the Court of Appeal. I'm going to develop this into a non sequitur, where they've gone from that to saying that we've accepted what we call compartmentalisation, which we haven't at all. But the bold assertion, first you can have it one way, you can have a fair relationship that becomes unfair, plainly. So that's clear. It may be something to do with enforcement, which is the bugbear. The principle that an unfair relationship will become fair is one we accept. The practice of an unfair relationship becoming fair is much more difficult. And we're very careful in relation to what we say there. And the mere fact that a relationship, once unfair, can in principle become fair, does not inform the court that means that it should make an assessment at a given point in time in the relationship, but not the end of the relationship or the date of trial. It's just a non sequitur. Just doesn't
It's a process of analysis as opposed to a conclusion.
My lord, yes.
Is that right?
But does it have the consequence that if, let's suppose a relationship is unfair at a particular time, and before or perhaps even after the debtor starts proceedings for relief under this section, the creditor does something which removes the unfairness so that it's no longer unfair? Does your analysis that you have to look at the fairness question at the last possible date mean that even though there was a right of action when the proceedings started, there no longer is by the time you get to trial?
Well, my lord, it really does turn on what this magic thing is that's done, because the most obvious way of looking at it would be to say, well, what if the creditor makes a Part 36 payment or an offer of payment of the full sum, by which we mean the sum, the interest under the contract, and interest for the delay. So it makes an offer. That would be the creditor's ordinary analysis for saying, I've now rendered the relationship fair. We're very careful in our case to say, maybe, maybe not. It's very fact sensitive, because actually this is all again, and I don't wish to aggrandise matters in saying the PPI scandal, but I think I quote from Lord Justice Briggs in Plevin when I use the description PPI scandal. But when you've got something which has been going on for as long as it did, to the extent it did, what it can actually be seen as achieving, one way of looking at it is that banks have used borrowers as banks, because they've used them to borrow money from them, which they can go off and invest to do whatever it is they want to do to increase their profits, and say, oh, don't worry, because when it all catches up with, we'll simply pay you back your amount, we'll pay you contractual interest, and we'll pay you simple interest. And so it may be, depending upon exactly what lies beneath, that simply saying we'll pay those sums is insufficient. Now, no case has been run on that basis. That's like taking an account and saying, I want to chase you now for the profits which you've made on the back of this system. And cases have been run on an individual basis, and they've settled where the appropriate sum has been offered. So it doesn't lead to a practical, a sort of analytical difficulty, if I can put it that way, if for these purposes it's treated as being the case that payment of the full sum plus interest renders an unfair relationship fair, then payment of that sum, which is then accepted, means the case settles anyway. So you have at that one point in time a relationship becoming fair.
I'm thinking of the other possible example, which you may say doesn't exist, where something is done which makes the relationship no longer unfair, but falls short of, if you like, full restitution or full affording of the remedy which the party making a claim in relation to an earlier period is seeking.
Yes, well, my answer to that would be then almost certainly whatever this magic thing is that's been done, it hasn't rendered a relationship fair. That's the point. If there are economic consequences that are adverse to the debtor, and so the creditor has taken partial steps, then I, for one, cannot understand how it can be said that those partial steps has rendered the unfair relationship fair. So great care has to be taken before just leaping to a step which is otherwise deemed insufficient and nevertheless has rendered an unfair relationship fair.
You're going to come back to that in the context of these cases, presumably.
In the context of these cases, there were no payments until the FCA's redress scheme, and it was the FCA redress scheme that notified the debtors that they had paid a very substantial commission, the exact detail of which we still yet to be provided with. So we can't say it's 92% or something as we did in Potter because we don't even know.
But conceptually, there's no problem with a case where, had a claim been brought 10 years ago, it would have been said then that the relationship was unfair. But because the creditor has perhaps made some redress after that and lowered the interest rate or whatever, at the time that the claim is brought and looking at the whole relationship as it stands now, the result is it's not unfair.
Conceptually, my lord, exactly. Conceptually there's no difference. Sorry.
Or even if the relationship were to have ended before the proceedings were issued.
Yes, then we've got the last date as already fixed in time, so we can then just look at the last date and say what's the position as at the last date. Now, strictly speaking, in that case it's slightly different because if it's the last date, then payments which are offered after the last date aren't relevant to the assessment because the assessment's as at the last date. But you'd end up in a world where claimants wouldn't pursue it because there would be no...
then there'd be no remedy. It would be less...
So in the real world, the problems don't arise, but in terms of the analysis, respectfully...
Locating it back in the section again, 140A4
yes,
doesn't continue by saying may have ended or have continued but ceased to be unfair.
My lord, you're in 140A1.
Sorry, 140A4.
4, I'm sorry. Determination may be made under this section of relationship, notwithstanding that the relationship may have ended.
It doesn't go on and say or continued, but no longer having, but ceased to have been unfair.
It doesn't, my lord. I mean, I would, for our part, we would accept that an unfair relationship can be rendered fair. Great care needs to be taken before seeing how on the facts that occurs, but conceptually as...
But I think you accept, don't you, that if it is made fair, if that's satisfied, then a claim which might have arisen from a period when it was unfair ceases to exist. The claim ceases to exist, and what would happen is you brought your claim properly, then something happened which rendered it fair. You'd get your costs up until the date that it was rendered fair, and you'd have whatever it is that they're giving you, because otherwise it can't be rendered fair, and the litigation would close. And that's a workable, proper system. There's no difficulty with that. I can put it that way. I was only going to finish off this part of my submission by inviting the court, because I've dipped in and dipped out, but to obviously consider with care the Patel judgment from paragraphs 62 to 67. So I've done a dip in, dip out, but the whole passage is extremely important. And I'll just give it a reference again. It's pages 523 to 525. In terms of where the Court of Appeal respectfully went wrong, I think it may be helpful if I try to provide a short summary of the Court of Appeal analysis, but I'm going to have to do this at some speed, but I'll give references along the way, but I don't propose to take the court to the passages. That's okay, to save time. This is the Court of Appeal's analysis. The court must perform an assessment as to whether the relationship is unfair, to which the answer is yes or no. That's paragraph 45 at page 169. Approving Patel at paragraph 64. So that's para 45, yes or no. When performing this assessment, the court must have regard to all matters it considers relevant without temporal limitation. And that's two passages. Paragraph 45, approving Scotland at 82, which I've taken you to, judgment of Lord Justice Kitchen.
and it's paragraph 63, which is at page 174. I can see your leg wants to go to it, so I'll probably best just take you to this. So para 63 is at page 174. And A, the Court of Appeal says it's clearly correct that the court must consider the whole relationship when deciding whether the relationship is unfair at the relevant moment in time, at the relevant moment that the question arises. And the page 169 reference is para 65. Page 169, para 45, in which the Court of Appeal says, I respectfully agree with all of this analysis. And that's setting out para 64 of Patel. And so far, the appellant doesn't take issue with the Court of Appeal analysis. But then the Court of Appeal held, first, that it was not necessary always to select the relevant date as a date when the relationship ended. And that's paragraph 58, page 172. The second point is, I would not say the relevant date always and necessarily has to be the date when the relationship ended. And the court can make a finding the relationship was unfair at one time, but that the unfairness ceased at some stage for some other reason. Para 61. And that's the misquote of our submission, but I've made that submission already. It doesn't matter ultimately, but that's what the Court of Appeal is doing at paragraph 61. And in this case, the relationship was unfair up till 2006. That's paragraph 66. So 66 between F and G. The credit relationship up to April 2006 was clearly an unfair one. Does the court see that? But it ceased to be unfair, see paragraph 68 to 69, from April 2006 onwards, when the last PPI payment was made. That's 68 to 69, but I'm not going to read through them if that's okay. And so the debtor is able to sue in relation to the unfairness up to 2006, provided an action is brought within 6 years of 2006, and that's para 69. You'll see para 69. April 2006 is the date when time started to run for the third line for the purposes of limitation. Since the claim form was issued in 2015, the claim is statute barred by Section 9 of the 1980 Act. In other words, in terms of, and it's our word that we introduced, I hope not confusingly, of compartmentalisation. Per the Court of Appeal, an action can be brought in, say, 2011 on the basis that the relationship in 2006 was unfair, even though the relationship in 2011 is fair, per the Court of Appeal. That's how it operates under the Court of Appeal's analysis. In terms of errors in the Court of Appeal's analysis, can I take it in three parts? First, the Court of Appeal has held it's permissible to make the assessment as to fairness of the relationship other than at the end of the relationship. Secondly, the Court of Appeal has held the relationship as of 2015 was not unfair to Ms. Smith. And thirdly, these errors are highlighted by the Court of Appeal's finding Ms. Smith never had a claim falling within the scope of the new regime. That's para 70 of the judgment. Can I take those in turn? The first is, our case is, the assessment of unfairness cannot be compartmentalised. Compartmentalisation is taking a relationship from 2000-2015 and bringing an action in relation to unfairness at any date other than the end of the relationship, or multiple dates, as we'll see. The Court of Appeal's approach is respectfully inconsistent with the statutory language and proper construction of the legal right for the reasons I hope I've set out sufficiently already. It is wholly at odds with that which Parliament has provided for by way of legal right of action under section 140A. And it leads the court in making an assessment in, say, 2008 to ignore conduct after 2008. It has to, because it's only assessing fairness or unfairness as of 2008. And that means the Court of Appeal was not following its own injunction that the court should have regard to the whole of the relationship without temporal limitation, passages which I've set out already, in which they said that's what we need to do, but they haven't followed it through. And that's because it was based upon the non sequitur that I've sought to identify already, namely that because a relationship can change over time, that meant the court could make an assessment of the fairness of the relationship at any point in time. It doesn't. And it also leads to intolerable consequences in practice. It means, as I've already set out, that a court can make a finding in 2011 a relationship was unfair in 2008, even though the relationship in 2011 is fair, which is going to make it very hard for the court to fashion a remedy for the unfairness when the relationship is now fair. Let alone if the episodes of unfairness are multiplied, which logically, on the Court of Appeal's analysis and expressly on the respondent's case that I'm going to come to when he addresses limitation, they are. There are multiple causes of action based upon payments. Has to be that way each time there's a payment. So what if there are multiple different episodes of unfairness, and they can relate to a whole range of issues, as we see, in terms of the agreement, steps in relation to enforcement, something done, something not done during the currency of the agreement, before the agreement, before the related prior, earlier agreements, and so on and so forth, to do with, only with the related agreement. All of those matters. If you've got all of these discrete findings in relation to episodes of unfairness, then you have to provide and fashion a remedy for each one, which is proportionate only to that episode of unfairness.
Why does that follow? I mean, take the unfair prejudice remedy in relation to the affairs of companies, just as
in relation to
affairs of companies, unfairly prejudicial conduct, which is a remedy in relation to the conduct of the affairs of a company that's unfairly prejudicial to one or more of its members. You have the same thing. The cause of action, if that's what, the right of action, is based upon showing there's been unfairly prejudicial conduct. Now that, if it's disputed, boils down into a litany of acts of unfair prejudice. But nobody suggests you get a separate remedy for each one. You look at the matter as a whole and
exactly,
decide what the appropriate
that's the system as it's been drafted by Parliament.
Yeah.
You make an assessment of unfairness. That's the yes-no. You then identify the basis or bases upon which you have determined that the relationship is unfair. See, by way of perfect working example, Patel.
Yeah.
And then you apply a remedy proportionate to the unfairness you've identified. This system says, take a relationship, forget about the transitional provisions for a moment, just take a 20-year relationship. You can sue on year 2 in relation to an episode of unfairness that you've identified with that's no longer than 6 years you've got from 2002, say, 2000 to 2020. You can sue within 6 years of 2002 for something you're cross about in 2002. In the meantime, your relationship's fair. Therefore, it's become fair. It's difficult to understand how you're getting remedy because it's just become fair. But you can have multiple steps of these, and each claim can be brought separately. You can have one that you bring within 4 years of an episode in 2003, but you might bring one within 6 years of an episode in 2002. All of these are separate claims which are brought because they're separate causes of action. And at each stage of the process, this is this system. not what we say is the proper analysis, which tracks very much an act I don't think I'm familiar with, but the provision is described in relation to the Companies Act, which is a single assessment. This isn't a single assessment. This is a multiplicity of assessments approach, because this is to say you can complain at any stage and say, I'm complaining about an episode of unfairness. And then the court has got to combine the remedies, which are separate in time. One might be given in 2004, the next one in 2006, but trying to make sure it doesn't compensate for the unfairness which has already been addressed, but at a time when the relationship may be fair again.
My difficulty, Mr. Weir, is just understanding why one jumps from a conclusion that you can look at a period of a relationship which was a historic period of a relationship from date A to date B, which was unfair, maybe 10 years, when the relationship was throughout that period unfair, and say, well, that just means you're looking at episodes of unfairness. But why aren't you just looking at a period of unfairness, which will no doubt be proved by reference to episodes, like everything always is? And why are you saying that that necessarily involves a number of causes of action?
Because this is what we describe as compartmentalisation.
I know you do, but
if the court, but I try to avoid that word, because you may say, well, that's a word we've put in and it's not helpful to the analysis. Fine, take the word away. If that's right, you're not limited to 2 actions. You can have 22 actions. Because you can have these relationships which have got multiple different steps, and what's being said is you can draw out one, I'll call it episode of unfairness, and you can choose to bring a claim within 6 years of the end of that episode of unfairness in relation to that, just that part. And they're all going to cross over. You can have a related agreement sat on top of a credit agreement, and the court has got to fashion remedies at each stage at the time that they're asked to, when the relationship may have gone back to being unfair for different reasons or fair for a different one. It doesn't make any sense. It's not workable. The simple and effective is almost always best Occam's razor, and it works here. You make an assessment at the date of trial or the end of the relationship to assess whether the relationship is fair or unfair. If it's unfair, you have regard to all of the reasons, which may be one or many, as to why it's unfair, and you fashion an appropriate remedy in one go. The second part of our submission as to why, respectfully, the Court of Appeal erred is that the relationship was unfair as of 2015. And the starting point for this is section 140b9, and that's at page 380. Can I invite the Court, please, just to go to page 380. So this is section 140b9. If in any such proceedings the debtor or a surety alleges that the relationship between the creditor and the debtor is unfair to the debtor, it is for the debtor to prove to the contrary. The position is a fortiori in this case, where it's common ground that the relationship was unfair in 2006. So not only does the respondent have to prove the relationship was not unfair in 2015, it also has to show that what's happened following 2006 has somehow rendered an admittedly unfair relationship fair. Hence my description a fortiori. And what would be needed, borrowing again from the language of Lord Sumption in Pleven, which I'm going to invite the Court just to turn back to, it's at page 542, paragraph 19. It's the same little 2 at B. So just picking it up again, if he fails to take such steps as 1, it would be reasonable to expect the creditor or someone acting on his behalf to take an interest in fairness, and 2, would have removed the source of that unfairness or mitigated its consequences so the relationship as a whole can no longer be regarded as unfair. And in our respectful submission, there has been no such conduct. All that's happened is the creditor has kept hold of all the sums paid over in relation to the PPI policy as a result of its non-disclosure of its commission. That's all that's happened in 2006, is having slowly got the money, it's held on to it. And using the language of the Court of Appeal below, the debtor has continued to feel the economic effects of the non-disclosure. And the creditor has continued to hide from the debtor the fact and amount of its commission. And that non-disclosure, as I've already submitted, continued unabated until redress was provided under the FCA scheme. So nowhere do we see steps being taken which have removed, let alone mitigated, the unfairness which by common ground existed in 2006. And that is why we employ the analogy that the well has been poisoned. And nothing after that time has happened to change its poisonous state. And the position is relevantly the same as it was in Patel, as it was in Scotland, and indeed another case called Nelms in the Court of Appeal, which is at 951, where the whole history of the relationship, including matters arising more than 6 or 12 years prior to the date of issue, informed the court's assessment as to whether the relationship was currently unfair. Nelms is another case. That's one where there was a payment by the creditor to the debtor's agent, which payment took place more than 6 years before the date of issue of proceedings. Scotland was all about misrepresentation by the double glazing salesman more than 6 years before the issue of proceedings. And as we know, Patel was about, amongst other things, the terms of a 1992 credit agreement being unfair to the debtor, when the claim was litigated in the High Court in 2010.
It's quite important, isn't it, to keep separate the limitation from the right. In fact, your point you made at the beginning,
very
because the first question surely has to be, ignore limitation, because that's a defence. Is the whole relationship viewed as a whole unfair or fair? Well, if as a result of what's happened recently, it is not unfair, then the claim fails anyway. You don't need limitation. That's just an assessment of the claim.
That's how it works.
If it is unfair viewed as a whole, then you come to the next step, which is, does somehow it nevertheless get barred because of a limitation defence? And that has to be a separate analysis.
Separate and logically consequent. Yes, my Lord. We respectfully entirely adopt that observation. My third submission related to paragraph 70 of the Court of Appeal judgment below. And can I just take you to paragraph 70? I haven't done to date. That's at page 175. That's where the Court of Appeals say, furthermore, so page 175, furthermore, although the point was not argued on this basis, our provisional view is that since the unfair relationship ended before the coming into force of sections 140A to C, an action for what was an unfair relationship in 2006 doesn't come within the 1974 Act at all. Now that flows from what we call compartmentalisation, because the Court of Appeal is saying...
You're right on the points you've made to us thus far, that this point falls away.
It completely falls away, we don't get there. But the reason I... So there was a discussion on our side as to whether it was strictly an issue before the Supreme Court at all, because it's more of an academic issue. I was content for it to be kept in as an issue because, in our respectful submission, exposes the difficulties of the Court of Appeal's analysis, because if you choose to say, well, this unfairness stopped in 2006, then what you actually end up with in a case, don't worry about Ms. Smith, whether Ms. Smith herself has got an extortionate credit bargain agreement, because, well, let me just explain this point now, because you can have a case where it was a condition of obtaining a loan that a person take out a PPI policy. In such circumstances, the PPI policy forms a part of the total charge for credit, and that's page 671. This is the old law. So that's something that's called the Consumer Credit Total Charge for Credit Regulations 1980, which is at page 671. And that means that's all part of the credit bargain, which you can see from page 596. Section 137 of the old extortionate credit bargain provision, but section 1372B2, credit bargain, where one or more other transactions to be taken into account, means the credit agreement and those other transactions taken together. And so you can have a case where, under the old regime, a debtor says the PPI, forcing me to take out a PPI policy as a condition of getting a loan renders my credit bargain extortionate. Please go to page 598, section 138. In which various arguments can be employed under section 138. You can say, see section 138(1)A and 1B, that it required the debtor to make payments which are grossly exorbitant or otherwise grossly contravened ordinary principles of fair dealing. Now that case, the strength of that case isn't the issue, because after all, the purpose of section 140A to C was to enhance consumer protection, precisely because the protection afforded by the extortionate credit bargain agreement was not out of the top drawer. So it's not about the strength of a case, it's about how someone could enjoy the right, at least, whatever right Parliament had given them, to go under the extortionate credit bargain agreement until a new regime comes in, and then they're either got to be in one or the other. There can be no possibility that Parliament intended people would fall into a vacuum between. But that is precisely the effect of the Court of Appeal's analysis, because if one then goes to the transitional provisions, at page 390, paragraph 15. So page 390. Para 15. This is the paragraph dealing with extortionate credit bargains. And it's set against the backdrop, if you see, it starts off, the repeal by this Act of sections 137 to 140 shall not affect the court's power to reopen an existing agreement under those sections. And if you go to little 7 on page 391, it defines existing agreements. Does the court see that? Existing agreement means a credit agreement made before the commencement of section 22(3) of the Act, and that's made before 6 April 2007. And section 22(3) of the Act we don't actually have in the bundle, but it says sections 137 to 140 of that Act, brackets extortionate credit bargains, shall cease to have effect. So that's what it provided for. But that obviously leaves open what exactly is meant, hence the introduction of paragraph 15 to provide complete clarity. Because the combination of paragraphs 15.2 and 15.3, which I'd just invite the court to read, and I won't read out because it'll take too long. Is that where the credit agreement becomes completed before 6 April 2008, or an application is made before 6 April 2008, the old credit bargain regime will apply. But otherwise, it will not, because by section 22(3 it ceases to have effect. And this is a case in which the credit agreement endured beyond 6 April 2007 and no claim was made by 6 April 2008. So a case such as the example I've given you couldn't be brought under the extortionate credit bargain agreement, but nor could it be brought, per the Court of Appeal's analysis, under Section 140A to C, and that's an outcome that simply can't be contemplated because Parliament never creates vacuums of that nature. The whole purpose of a transitional provision is you're going to have a set of cases which fall within the old regime, and then anything that doesn't comes within the new regime, not some of them fall betwixt and between. And that is not answered in the respondent's case. There is no answer, and that's because there is no answer to that. The only answer given is on the basis, oh, well, Ms. Smith didn't have a claim. It's not about Ms. Smith in this context. It's about the proper construction of Section 140A, having regard to the transitional provisions as exposing how respectfully the Court of Appeal's analysis simply cannot be right. The respondent makes a number of additional arguments in its case, which I'm going to hope to be able to go through, but I'm certainly going to do this with some speed before going on to limitation of transitional provisions. This is the respondent's case at paragraphs 50 to 72, and I'm just going to have to, rather than take you to them and let my learned friend develop them, but I'm just to say our case. His first one is to say that fairness is more complicated than yes or no, and that's his para 121, which we say, just because you then look to see the nature and extent of the unfairness doesn't mean that you don't, prior to that, have the question, is the relationship unfair or not? You do. And then he says Section 140A contemplates multiple causes of action. That's his para 122. And he's at page 122, sorry. I think I'm saying para, but it's page 122. And that's when he says that, look, you can see that there are claims for sureties and there are claims against people other than creditors. And I've addressed that early on. The gateway is Section 140A. Nothing about the remedies being open to different claimants against different defendants affects the proper analysis of Section 140A, which is not about sureties, it's not about associates, it's about the relationship between creditor and debtor. Then he says at page 123, unfairness must sometimes be determined other than by reference to the present, because otherwise it will lead to a grossly unfair result, for instance, for a surety, to which we would say, how so? Once it's recognised, past conduct can give rise to present unfairness. There's no difficulty for a surety in establishing that the present relationship is unfair if nothing has happened to remedy whatever unfairness it is that's arisen in the context of the surety. Then my learned friend raises the issue of insolvency and says it doesn't work because when the trustee takes over the right of the debtor during the course of the relationship, the trustee can't then bring a claim later on in relation to the relationship. And that, respectfully, we say simply isn't right, and if it was right, would mean that the Insolvency Act didn't achieve its purpose, which is to allow the trustee to maximise recovery of funds for creditors. And it's every step has been taken by Parliament to ensure that such an odd outcome is not achieved. If we just track it through, what transfers on bankruptcy is property, and we have in the bundle Section 283 of the Insolvency Act at 621 and Section 306 at 625. And property is defined in Section 436, which is at page 635. So that's page 635, and I might invite the court please to turn this up. You'll see under little b near the top, property includes, does the court have this? So I'm on page 635, near the top, property. Includes money, goods, things in action, land and every description of property wherever situated, and also obligations and every description of interest, whether present or future or vested or contingent, arising out of or incidental to property, which is about as broad as it can get, and will include what I hope I describe accurately, but quite prepared to be overruled on this by the court, as the right to bring statutory claims emanating from the credit agreement, so long as it endures. Those more familiar with the contours of insolvency law than myself, which will be every member of the court, may have a different way of putting it, but I think the court understands the submission which we're seeking to make. It must be the case that the trustee inherits then all of the rights to continue to bring a claim, statutory claim, arising out of the relationship from the credit agreement, as long as that credit agreement endures. And there's a case which has been introduced by my learned friend, which I invite the court to look at, which it may find helpful, the judgment of Stephen Houseman QC in a case called Shock Direct Finance. And I'll just give you the reference, paragraphs 46 to 51, at pages 1281 to 1282, that the court may or may not find of assistance in terms of analysing out the breadth of property and within the terms of the Insolvency Act. Learned friend then says at page 124 that always determining fairness by reference to the present distorts the meaning of unfair. So the respondent invites the court to ignore conduct in the past which renders the relationship unfair, but it's contrary to the language of section 140A, which requires the court both to assess whether the relationship is unfair and to have regard to the whole of the relationship. And it's a return to the same underlying complaint, which is Parliament couldn't have intended to allow the debtor to bring a claim during the course of an ongoing relationship which is unfair, where the source of the unfairness started or occurred years ago. That's the sort of baseline complaint that's being made again and again by reference to this is all about limitation and stale claims, but it's precisely what the statute does to enhance consumer protection. And it's not a stale claim, and perhaps we'll come on to this later when we get to limitation. Ditto with the next complaint at page 125, which is really more of the same. The suggestion that Patel and Scotland don't compel a different conclusion, it's not that they're binding on this court, but for the avoidance of doubt, the importance of Patel and Scotland lies in the analysis by the courts of the meaning of section 140A. So that you can say they're wrong, but you can't say, oh, well, I'm going to distinguish the cases because they're on different facts. That is a straight-up, prior analysis of the proper interpretation of section 140A by both courts, then applied to the facts of the individual cases. And the last one at page 127A's criticism of the Court of Appeal's analysis of the facts, I think I've already sufficiently addressed. So can I then turn to limitation? And for the avoidance of doubt, our case is set out at paragraphs 73 to 83 of our case, pages 98 to 100. And can I start by making this submission? The respondent's case that the claims are limitation barred proceeds recognising, or even if, the determination of unfairness must be conducted by reference to the present. For this, please go to page 129. We're in the respondent's case at paragraph 75. So the argument on limitation that the respondent is raising only proceeds, if you see para 75. Alternatively, even if, as the appellants say, the determination of unfairness must always be conducted by reference to present, the respondent submits we're out of time. So that's the premise upon which the limitation argument flows. Because, of course, if the Court of Appeal was right, the relationship isn't unfair in 2015, it's unfair in 2006, and if that was right, well, obviously we're out of time. So this is an argument that's only in play on the premise that the respondent accepts for these purposes that the relationship cannot be compartmentalised. And our case on limitation is as follows. First, the claim brought in 2015 was in respect of the relationship in 2015, and so was brought in time. And secondly, the respondent's submission is internally inconsistent, as it involves a return to compartmentalisation contrary to the premise that I've just set out. So in terms of the claim was brought in 2015 in respect of the relationship in 2015, I've obviously worked my way through the statutory language. I'm keen to avoid repetition, but can I just emphasise the following? If you just go back to section 140A, the key question is the relationship unfair? Not because of. The because of is why it may be unfair. The mistake or error or trap is to look at the because of and go, well, those because ofs occurred at an earlier stage. Ergo, I'm looking at an earlier stage. You're not. You're looking at, is the relationship unfair? The because of is because of a range of factors, which, as I've sought to set out, are across the full temporal scope of the relationship and or even before query. And the Court of Appeal below, in our respectful submission, was right when it says at paragraph 54, and can I take you to this, please? This is page 171. Just below E, after the sentence, I'm on page 171, para 54 of the judgment of the Court of Appeal. Just below E, after the Court of Appeal says the claim is for relief from an unfair relationship, it says, a relationship is something which continues over time. If a relationship happens to have been in existence for a very long time is still unfair on a given date, e.g. 2015, then in my judgment the act is clear that the debtor can bring a claim under the section and seek appropriate relief for the unfairness identified. The fact that unfairness occurred in the past may or may not assist in assessing the question whether the relationship is unfair on a given date later on, but crucially, the fact a relationship was unfair yesterday is not the same fact as the relationship being unfair today. The facts necessary to make a claim for the unfairness on that given date cannot be said to have occurred until that given date. Which is nicely put, because it's not so easy to actually draft up what we mean, and that's been very well put by the Court of Appeal. And see also how the Court of Appeal at that point, para 55, then approve that which Mr. Leggett set out at paragraph 66. And if you go to, we might as well stay within the Court of Appeal's judgments are on page 172, and between B and C. And note how straightforward the point is for Mr. Leggett. If I'm right in my analysis of the date at which the fairness of the relationship between the creditor and the debtor falls to be assessed, the result is that the debtor's cause of action is a continuing one which accrues from day to day until the relevant relationship ends. It follows, in my view, an application under 140B can be made at any time during the currency of the relationship rising out of the credit agreement.
Yeah, so you say that the fact that the debtors could have sued on the 7th of April 2008 for the situation as then is irrelevant because of this reason.
My lord, yes, it's different.
It's hard to see how limitation comes in if it's correct that the claim is, as they seem to be accepting in 54, based on the relationship when it ends, because either the relationship's fair then because of everything that's happened, in which case you don't get to limitation, or it's unfair, in which case limitation doesn't arise. It's only once you start postulating that you might be able to bring now a claim based on the relationship being unfair at some time in the past, but you can't do that under the Consumer Credit Act. There isn't such a claim.
My Lord, that respectfully encapsulates our submission. I was going to say that in the Potter case, which Lord Kitchen is involved, in which we wait with bated breath for a judgment to be handed down in due course, I raised before that court the question of whether or not anyone knew of a statutory cause of action that involved a relationship other than Section 140A. I had no response. It may be that members of this court know, but it's, to me at least, and with very limited knowledge of the world of insolvency law, etc., it seems to me possibly to be unique and certainly highly unusual. And these consequences flow from Parliament's express choice to home in on relationship and not to home in on acts or omissions or date of agreements or such like. It's a natural flow from relationship when the court expressly by Section 140A is charged with is the relationship unfair. So these are simply the consequences that must flow in our respectful submission. And that's why we say it's inappropriate, using the language favoured in limitation cases of whether a claim is stale, to talk about the claim being stale at all, because the claim is made within 6 years of a relationship that we're complaining about and that we say was unfair in 2015. Staleness doesn't come into it. It's then said against us that it leads to absurdity. That's the Respondent's case at paras 94 to 95 at pages 134 to 135. But that, as we say, is the nature of relationships arising out of a credit agreement that will continue for long periods of time. And Parliament was entirely untroubled by establishing a regime in which unfairness could emanate from the terms of the earlier credit agreement subsequently consolidated into the relevant credit agreement, whenever the earlier credit agreement was formed, as I've set out at paragraph 16 of Schedule 3 to the Act. In other words, its eyes open. Parliament's eyes were completely open to credit agreements by their nature endure for long periods. And here the scope of the court's inquiry was not one that one might think, well, that's probably only going to be a couple of years. It was absolutely express. It's immaterial when the prior agreement was started, which was subsequently consolidated. So the facts of Patel, again, form a good working example or a paradigm for this happening when you have loans which subsequently consolidated, which go back to the 80s. And on the issue of interest that the respondent complains about and says, well, Section 69 of the County Courts Act doesn't work in this context because it provides that interest will be payable between the date when the cause of action arose and judgment, and on your case, the cause of action that you're suing on doesn't arise until 2015. Can I note the following? If you go to page 228, please. You're in the particulars of claim in Smith, and I should say that the particulars of claim in Burrell are materially identical. That's 4 volumes. And you'll see at the end that there is no claim for interest under the County Courts Act 1984. If you go to page 227, you'll see what was claimed at paragraph 14. In order to remedy the unfairness, the claimant applies under section 140B2 of the CCA 1974 for the following relief. Under section 140B1A, in order for the repayment of sums paid in an amount equivalent to the premiums charged to PPI policy and contractual interest, and under B, under section 140B1A, in order for repayment of sums paid in an amount equivalent to simple interest. So it wasn't claimed under the County Courts Act, it was claimed under section 140B1A. And that sum was awarded. If you go to page 178, please, you've got the order of District Judge Stone. The court can see that. It's page 178. I can see my Lord Legate's looking at 140B1, and I'll go back to it perhaps in just a second. But just to track this through for the moment. So page 178 is the judgment of DJ Stone, and the court can see judgment 1A was the sum of 735 being reimbursement of PPI premiums and interest payments made after the deductions of the sum already paid, in other words, contractual interest. And B was, additionally to that, the interest that was claimed separately. And that was recovered from 2000. And we can see that there was this. What happened was there was a separate judgment on the issue of interest. The counsel were unable to agree a transcript of what was ordered. But we see from His Honour Judge Gore's judgment on appeal, if you kindly go to page 190. Paragraph 24, right at the bottom, 24.7. So you're now in the appeal, the first appeal judgment, that of His Honour Judge Gore QC. Do you see it says interest thereon will be awarded from 2000? Does the court see that?
I find it hard to see how interest, though, is repayment of a repayment of a sum. Isn't it better just to say it's at some other? Put it under B or one of the other things. It means you can do anything you like, basically.
My Lord, the discussions with my learned junior, who has both attended and been deeply involved in the higher courts and at a more granular level on an ongoing basis in battles with my learned friend for Respondent and others. That's exactly the conclusion that we reached yesterday, that it would certainly be open to a claimant and the alternative to claim under 140B 1B. But in relation to 141A, can I emphasise that the provision says require the creditor to repay any sum paid by the debtor, and it's not necessary under that the sum that you're seeking to reclaim the very money that you've paid over by way of additional interest. There's contractual rate interest that was paid but nothing else. And we see that from Nelms, because Nelms is an example of a remedy being provided to a debtor for a payment made by a creditor to the agent of the debtor. You don't actually have to have a payment out from the debtor in order to get money back in. All you need is, if you like, the cap on it is the total amount that you have paid the creditor, because it just says any sums, you can't go beyond the full amount that you have paid the creditor over time, which of course, a credit card for 15 years would be a lot of money. So that's how wide, and it's all in line with what Lord Sumption says in Plevin, the width or breadth of the operation of these provisions. Deliberately so, he sets that out in terms. Parliament has been deliberately broad in the way it's put, and as my Lord Legate says, certainly it can be under 1B, and my respectful submission, it can also, for that reason, be under 1A. It has been under 1A in this case, and it's not the subject of a further appeal to this court. In relation to the submission I made that the respondent's case is internally inconsistent, the respondent's case can be best seen by going to page 133, paragraph 91. And so it's page 133, para 91 at the bottom. And here the respondent says the conclusion which the respondent submits is straightforward, is that time started to run in respect of each month's premium when it was paid. And that's why I say we're in this monstrously multiplicity world, because that's their real case. Although the Court of Appeal says, oh, well, limitation runs from 2006, from the date of the last payment, it's not intuitively obvious, certainly to us, why they're allowing recovery of earlier sums than those. If you claimed on the last date in 2012, why on their analysis it's not one of those continuing causes of action like the European case where you just get the last 6 years of payments? It's not at all obvious why there's some magic in the last payments made and then your time for everything starts. So
it's a foot in the door argument, the Court of Appeals approach. As it were. If you're just squeak in time, then you get the whole lot, otherwise you don't get anything.
And it may not be my place to try to analyse out quite how and why this has happened, but we delicately try, or hope to delicately try, briefly in our written case, just because on the premise that where the Court of Appeal seemed keen to provide a remedy, but the error starts to occur when you think that unfairness can convert into fairness without much difficulty. And that's where it all starts to unravel. And that's why I've been so keen to emphasise, in response to observations from my Lord Briggs, what tremendous care needs to be taken to analyse out if you're going to track through some thought process, to actually understand what it is that in your thought experiment you're saying has happened that has rendered the unfair relationship fair, because it's far from straightforward to see unless it's a complete remedy. And as I say, in certain circumstances, if there is an overarching high-level policy to operate in this way, the court shouldn't be condoning it by going, oh, well, that's okay, as long as you paid up late, the cause of action is gone. It may be the courts in such a case would say, I'm sorry, that's not right. This is endemic conduct that we don't condone, and the relationship continues to be unfair, even though you're now offering the sum belatedly. And that's of course pure compartmentalisation in its most extreme form. That's causes of action accruing with payment after each payment, 6 years triggered in each one. And if you add that to other episodes of unfairness, that's what I was trying to get at, whether with or without success, and I perhaps won't go there again, seek to persuade Lord Briggs, but with the multiplicity of actions taking you down a real rabbit hole. Can I then please turn to the transitional provisions and how they do not operate to deny the appellants their rights of action? It's incredibly narrow, the basis upon which the respondents are now putting their case, and with respect, wholly untenable, because it's now, I believe, accepted that on the face of the wording of paragraphs 14 and 16 of Schedule 3 to the 2006 Act, which you'll find if you can kindly turn them up at pages 390 to 391. I'm hoping to take this part shortly, but I'll just tell you what I do understand to be entirely common ground. Section 140A, this is on the face of the wording. This is not, the respondent doesn't accept that we have a cause of action, but on the face of the wording, Section 140 applies to Ms. Smith's claim because she brought a claim after the 6th of April 2008. That's paragraph 14. So 14(1) and 2. But there is nothing in 14(1) and 2 other than to say that a person whose credit agreement continues beyond 2008 is entitled to the benefit of sections 140A-C. Section 140B, common ground, is amended by paragraph 16 to remove references to related agreement. See here 16.4 and 16.5, which again I won't read out, so it's pages 391 to 392, but I would invite the court just to scan read if possible. So if one then goes back to section 140A and section 140B, page 377 and then 379, at 377, that provision, section 140A1, is entirely untouched by the transitional provisions, including paragraph 16. That's common ground. There is no redaction from section 140A. And it's the relationship, we're now proceeding on the basis the relationship is unfair. We're in. That's our right. We now come to our remedy. We go to page 379, and what we have to do for these purposes is redact or strike a line through the words "or any related agreement." And because right at the bottom, as the Court of Appeal below explained, direct accounts has not used the word related agreement, it's a bit more wordy in paragraph 16 of Schedule 3, because it's not simply a question of striking out words because they're not there, but you can't have accounts in relation to the related agreement. And so if one goes back to 140B1A, which is the very provision that the claimant pleaded, relied upon and succeeded upon, it says an order under this section in connection with a credit agreement may do one or more of the following. A, require the creditor, and I'm going to ignore associates for a moment, to repay any sum paid by the debtor, ignore surety, by virtue of the agreement. And that's the credit agreement. And again, it is, I believe, now conceded that as a matter of fact, the sums were paid by virtue of the credit agreement. And I say that because if you go to the respondent's case at paragraph 122, page 142, so page 142, para 122 at the bottom, if that's right, it doesn't matter that the PPI premiums can in some sense be said to have been paid by virtue of the credit agreement. Even without that, what seems to me to be a recognition of the inevitable, the position it has to be as such. We have the judgment of District Judge Stone, which starts the whole ball rolling at page 212. 212, my Lord.
Thank you.
So if you can kindly turn this up. It's an exemplary judgment and said as much, but if you kindly go to page 212 and start at paragraph 28, just below the middle, you'll see District Judge Stone says, taking those findings together, I find that all sums paid towards the PPI policy were paid by virtue of the credit agreement. And the taking those findings together is his paragraph 27. And I'm not going to read it through now, but it's perfectly plain from paragraph 27. The PPI policy only existed to support the credit agreement. The PPI insurer was paid through the credit card agreement, which involved the debtor first paying the insurer and then being in debt to the creditor, and then at the end of the month or later with interest paying the creditor under the credit agreement. There can be literally no other way of analysing it. And then we see, for the avoidance of any doubt, the Court of Appeal's judgment, again, and none of this is appealed, and nor is it appealable. It wasn't appealable or appealed as a matter of fact before the Court of Appeal. So if you kindly go to page 170, paragraph 47, but on page 170 between A and B, therefore critical to the court's power to order repayment of the sums was the finding of fact by District Judge Stone, plainly open to the judge on the evidence and not challenged as a matter of fact on this appeal, that those payments were also made by virtue of the credit agreement itself. So, on the face of the clear wording of the statute, Ms. Smith, A, has a right under section 140A, and B is entitled, as a matter of discretion exercised in her favour and the facts of this case, has the right to apply under section 140B1A, which she did and succeeded on. And that really is it. The respondent continues to resist this conclusion by submitting, in effect, that Parliament cannot sensibly have intended this outcome. Now that's a tall order. because no longer are they relying on Hansard, and they're not relying on Hansard, which didn't support them, as the Court of Appeal found. With nothing to hide in Hansard, but it just didn't support them. But in other words, that's because they recognise that there's nothing ambiguous about Section 140A and B. So you've got clear wording, as the Court of Appeal found, clear wording of the effect of the transitional provisions, and a clear operation of Section 140A and B, and yet it still said somehow that wasn't Parliament's intention. That's the tall order that the respondent faces. So this is on the basis that the removal of the words related agreement is on the appellant's case of no effect. That's their para 121. Secondly, they say it would undermine the purpose of the transitional period. That's 124. And thirdly, their interpretation gives a new regime no greater retrospective effect than is necessary to achieve the legislative intention. That's 125. And can I take those submissions in turn? First of all, Section 140B1 has been materially changed by redaction of relate or related agreement. And the Court of Appeal recognised this at paragraph 48, page 170. Can I invite the Court just to have a look at that, please? So page 170, para 48, right next to C, not every payment made by virtue of any sort of related agreement will necessarily have been made by virtue of the credit agreement. The fact that that's the situation in the present case does not require the Act to be construed in the way RBS contends for. The Act simply doesn't prevent orders for payments made by virtue of the credit agreement. And the example we give is one at paragraph 98, which is where the credit card is used to pay a deposit on a timeshare, but the balance is paid by some other means. If that all occurred in the transitional window, then you can get the initial payment back because you can get a sum paid by virtue of the credit agreement, but you won't get back sums that you've paid by some other means outside of the credit agreement. And then my learned friend says, well, Section 140B1 doesn't work under this. So if we can kindly go back to 140B1B, it's page 379. He says it doesn't work because look at the wording that starts Section 140B1, an order under this section in connection with a credit agreement. And he then says the same language in connection with the agreement is used under 141B. So taking out related agreement changes nothing because all orders will be in connection with the agreement anyway, because they have to be to come within 140B1 at the beginning. Now that, respectfully, is not right. And it's not right for this reason. If you go to 140A, so back at 377, you'll see that that's described as the court may make an order under 140B in connection with a credit agreement, and the same language is used in 140B1. So that's about your right to make an order. And that order is in connection with the credit agreement for the reasons set out in 140A and following, because it's explained how it's all in connection with the credit agreement. So that's about the court's power to make an order. Section 140B1B uses in connection with in an entirely different way. Now it's about the content of an order so made, not the power to make one, the content. Because it actually, what it does is it requires the creditor to do or not do something specified in the order, if you like, A, in connection with the agreement, or B, but not in the transitional period, or any related agreement. So that is requiring prospectively the creditor to do something. It's nothing to do with the power under 140A and 140B1 at the top. It's to do with ordering to do something. And that means that, for instance, in a case such as this, you could not make an order that the creditor is required to indemnify the debtor in relation to the related agreement if it was ongoing. You couldn't make that order. And of course this all makes sense because we're only in this situation where the related agreement has come to an end. So it makes perfect sense. Unsurprisingly, you can't make a prospective order in relation to a related agreement that no longer exists. So respectfully, my learned friend is not right to say that this collapses into itself. It doesn't. It's got ordinary real value in removing related agreements. And it also answers the issues in relation to transitional provision and in relation to the retrospectivity point, because Parliament has acknowledged the need to address when does one scheme cease to operate and when does a new scheme come in by some pretty carefully drafted and detailed transitional provisions. It hasn't been one that's been left in very short order to the court to divine in its infinite wisdom how we've moved from one scheme to another. They're very sophisticated, very clearly set out. You track through those, and what it's done is say, I'm going to give you a transitional window, creditors, to, using the language my learned friend uses, get your house in order. And exactly as Deputy District Judge Crowe says in the Burrell case, it's page 321, at paragraph 59. When DGJ Crowe says, the difficulty with the defendant's arguments, it requires the court to go behind a clear statutory wording. It was suggested it would frustrate the purpose of allowing a transitional period for banks to get their house in order if allowance were made on a credit agreement for the purposes of a related agreement. However, that period could have been used by terminating credit agreements and starting afresh on the basis the relationship was unfair. So the creditors...
It was fair.
I beg your pardon, my lord.
The last word is fair, not unfair.
Yes, if I said unfair, that's a classic, one where you don't hear yourself, I'm sorry. Say the level opposite of what you should have done. Apologies. So, was fair. So they've actually got at least two options. They could say, oh, well, let's have a look at this new scheme. Under this new scheme, I don't suppose it's very reasonable for us to be holding on to an enormous amount of commission, which we didn't tell the debtor about. We'll own up to it and pay out. That's one option. Or they can say, let's see if we can use these transitional provisions to help us. Let's just terminate the credit card agreement and offer up a new one. Then the credit agreement would have ended and we wouldn't be in the new regime. That's paragraph 14 of Schedule 3 to the Act, transitional provisions. They've done neither. So this is the consequence. None of this involves any offence against retrospectivity at all. Indeed, it's almost rather the opposite. Parliament has taken a very careful approach because it has invited the redaction of the words by way of remedy or related agreement for these such cases. And as the Court of Appeal said in the passages I've taken the court to just recently, it happens in this case the payments were both by virtue of the credit agreement and by virtue of the related agreement, but in others they won't be. And as this court well knows, Parliament is entitled, to the extent there is retrospectivity, to provide for retrospectivity, provided it does so expressly. And here it's absolutely plain on the face of the transitional provisions how Parliament anticipated the transfer over from old scheme to new scheme would operate. And that's why, respectfully, entirely correctly, my Lord, Mr. Leggett, in paragraph 56 in Patel, took the issue in short order in relation to the transitional provisions. And I'll just end on that, if I may. It's page 390.
$390, did you say?
I hope it's 522. I do apologise. 522. Sorry.
Yeah.
I think that the date may be the 6th of April 2008 rather than 2007, taking into account para 14. But the point that's been made is there is the paragraph in which Mr. Leggett simply recognises, reads Schedule 3, and understands in the ordinary way its operation.
Sorry, which paragraph are we looking at?
56.
56.
56.
Thank you.
Short, and appropriately so. Its operation is entirely straightforward. If your credit agreement endures beyond April 2008, you're in the new regime. If your related agreement ended at that earlier stage, then your remedy is limited by removal of the words redacted or related agreement. That's it. Since we are by virtue of the credit agreement, that does not affect the appellants in this case. My Lords, unless I can assist further, those are our submissions.
Thank you very much, Mr. Wade. Mr. Taylor.
My Lords, it's common ground that under Section 9 of the Limitation Act, these claims for repayment are subject to a 6-year limitation period from when the cause of action accrued. It's also common ground that a cause of action accrues when the facts on which it is based can first be pleaded. And it's further common ground that the claimants could have claimed everything they now claim by no later than the 6th of April 2008. These claim forms were not issued until 2019, some 11 years later. We respectfully submit the claims are time-barred, and we also respectfully submit that given that the PPI policies in this case ended before the 6th of April 2008, that's before the end of the transitional period, the claimants have no cause of action on a true construction of the transitional provisions which introduced the unfair relationship regime. And my Lords, I propose to address my submissions under the following headings. First of all, policy behind the Limitation Act. Secondly, the approach to Section 9 of the Limitation Act. Thirdly, the Court of Appeal's analysis. Then the appellant's criticisms of that analysis. The bank's alternative case on limitation, and just on my learned friend submissions, they're not inconsistent. They are alternative cases that we put forward in our submissions. And then finally, the transitional provisions. Now, Lords, we've set out the policy behind the Limitation Act in paragraphs 10 to 18 of our written case. In summary, delay in bringing proceedings can defeat the very purpose of those proceedings, namely doing justice. Evidence is lost, recollections fade over time. Secondly, individuals and companies need certainty as to their rights and obligations. They should be able to plan their lives and their businesses on the basis that when the time periods in the Limitation Act have expired, they know that no further claims will be brought. All of those points are encapsulated by the well-known phrase that it is in the public interest that there be an end to litigation. That a learned friend suggested that those policies don't apply to a consumer remedy, and we respectfully depart company with my learned friend on that suggestion. The Limitation Act and the policies behind it apply equally to consumers as they do to those in business. For example, sections 2 and 5 provide a 6-year limitation period for individuals, consumers, to bring claims in contract or in tort. Similarly, in our case, section 9 applies a 6-year limitation period for those relying on statute to recover money. That applies equally whether you're a consumer or whether you're a business. Of course, there are some well-known exceptions to those primary rules of limitation. Section 32 of the Limitation Act, which your Lordships will be very familiar with in this context, postpones the running of time when the defendant has been fraudulent or has deliberately concealed a fact relevant to the claimant's case, or the claimant's case is based on a mistake. Section 32 can, of course, in principle, apply to these claims under Section 148C. And that's important because there is no policy reason to construe Section 148C so as to effectively create a primary limitation period that will preserve claims for literally decades. If the creditor has acted fraudulently or deliberately concealed facts, the debtor will be able to rely on Section 32. But in this case, neither Miss Smith or Mr. Burrell sought to rely on Section 32. This case concerns only the primary limitation period. When did Miss Smith and Mr. Burrell's causes of action arise to recover the payments they made in respect of PPI? And the facts are startling in our submission, my Lords. Miss Smith made her payments between 2000 and 2006. Those were between 19 and 13 years before she issued her claim form. Mr. Burrell made his payments between 1998 and 2008. Those were between 21 and 11 years before issue of the claim form. In fact, it's the appellant's case that not only did they acquire retrospective causes of action when Section 148(c) came into force dating back to the last century, but time didn't even start to run until their credit cards ended. So in Miss Smith's case, time didn't start to run until 2015, when her credit card ended, and time under the Limitation Act didn't start to run for Mr. Burrell until 2019. And in fact, if those credit cards had continued, time wouldn't have started to run for those claims on the appellant's case. And we respectfully submit that that approach disregards both the policy and indeed the wording of the Limitation Act 1918, in particular Section 9. So, my Lords, moving on to Section 9 of the Limitation Act. We've covered this in paragraphs 19 to 35 of our written case. The appellants do not seem to take great issue with what is said there, so I'll highlight the main points. First of all, whether a claim is brought under a statute is governed by a 6 or a 12-year limitation period depends on the remedy being sought. So if the claim is for money, it falls within Section 9 and is subject to a 6-year limitation period. If a different remedy is sought, it is governed by Section 8 of the Limitation Act and subject to a 12-year limitation period. In paragraph 21 of our written case, we've referred to the case of Rahman and Sterling, which was on the extortionate credit bargain legislation, as authority for that proposition. To the same effect is Hill and Spread Trustee, a decision of the Court of Appeal. It may be worth turning up that decision, which is at page 450. Now that case concerns Section 423 of the Insolvency Act, a transaction defrauding creditors, and the remedies that are available under that section are at page 487 of the bundle. And it's in particular Section 425, which is at right at the bottom of page 487. And if your Lordships might read that final paragraph, seeing the breadth of remedies that are available under this particular section. So, for example, they include ordering the transfer of property. They include reviving obligations that have previously been discharged. And they also include ordering repayment of money. And as Lady Justice Arden said at 478, as she then was, this is at the bottom, 478, just beneath letter H. Of course, the court has jurisdiction to make some form of order other than payment of money, but it is established by earlier decisions of this court that where statute enables the court to give relief in monetary or non-monetary form, the court should look to see what is actually claimed. And the reference there to the West Riding case. Insofar as relief sought is not to recover any sum recoverable by virtue of an enactment within Section 9 of the 1980 Act, I agree with the judge that this is an action on for a specialty. So, when one is deciding whether a claim is governed by Section 9 or Section 8, one looks to see what remedy is being sought by the claimant. And as we'll come on to, we'll see that this was purely a claim for a monetary judgment. Now, in paragraphs 25 to 27 of our written case, we cite the well-known cases about what amounts to a cause of action. So we've got Coburn and College and Latang and Cooper. And if I draw your Lordship's attention to Latang and Cooper, that sets out the classic test. A cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against the other. At paragraphs 30 to 31 of our written case, we then set out that the cause of action arise when the facts could first be pleaded. It may be worth turning up at the House of Lords authority that we have referred to there, which is the Central Electricity Board and Halifax, which is at page 397, which is a case on Section 9.
If the relationship was unfair when the credit agreements ended, are you saying that claims are barred?
One has to ask why the relationship was unfair.
No, but if it was unfair, does limitation come into it?
Lord, it can come into it, yes, on our alternative case.
Right, only on your alternative case?
Yes, on the alternative case, yes. Yes. So...
And that's what your alternative case is there for?
Yes, my Lord, yes, yes, exactly, yes, yes.
I don't at the moment see how limitation arises if the relationship was fair at the end of the relationship. And there simply isn't a claim if the relationship wasn't unfair when it ended.
The question was being put was it if it was unfair at the end of the relationship?
Yes.
Not that it was fair.
Yeah.
Yes.
Yes.
Yeah, no, I understand that, but you were suggesting that was so on your. You were saying on your alternative case, then if it's unfair at the end of the relationship, it could still be time barred.
Part of the claim could still be time barred on the alternative case, my Lord. That's absolutely right, because the alternative case.
I totally understand that. What I was having a problem with is seeing how we get to if we ever get to limitation on the primary case, let alone the alternative, if the relationship was not unfair when it ended.
Well, that's right, Lord. If the
claim just fails, then.
Yes. Yes. Well,
so is that your primary case?
Well, my Lord, the claim for an unfair relationship as at the date of the assessment, the trial, fails. But as the Court of Appeal said, there is nothing precluding the court from going back and looking at the relationship earlier on.
Well, you're not picking up the poison chalice being offered to you by your opponent and saying, well, if on the very last day it's fair, then there can be no claim, even if for the previous 25 years it was unfair. Which I think is his analysis of how Section 148
yes, so in that circumstance it may be fair on the last day, but there's an accrued right to sue in respect of the unfair, which is within the limitation.
I think your opponent is advancing a really different construction, saying that everything depends on whether it's fair on the last day, assuming that it doesn't continue to a trial.
Yes, he does.
That's what is fair means. Is unfair means.
That's learned friend's case, my lord. But
It would have to be a pretty extreme circumstance which rendered an agreement fair on the last day
Yeah.
if it had been unfair the whole duration of the agreement up to that point.
it may be extreme, my lord. Yes.
So I understand the submission is one looks at the whole relationship as of the last day, you look back and decide in the light of that review whether or not it is or is not unfair.
Well, my lord, as I'll come on to, when we go through the Court of Appeal's judgment, we will see that in our respectful submission, that approach doesn't give effect to the reality that relationships change over time. What was unfair at one point in time can become fair. And particularly when, for example, in this case, the unfairness arises out of a related agreement which ended, in this case, decades before the court comes to determine the case. And I will come to it, but there is support in the wording of the Act to support the Court of Appeal's analysis that you should be looking at when the related agreement, the PPI policy and the credit agreement were in existence, and determining whether that relationship was unfair or not, and contrasting that with the relationship which you ended up with at the end of the credit card agreements, where the relationship only arose out of the credit card agreements. And that's perfectly fair relationship, as it had been for many, many years.
But there's only one relationship, isn't there, for the purpose of the Act, arising out of the agreement and related agreements?
Well, my lord...
or do you take issue with that?
We do take issue with that, my lord.
Right.
And one can see that from section 140A1. And if we turn that up to 377, the court may make an order under section 140B in connection with a credit agreement if it determines that the relationship between the creditor and the debtor arising out of the agreement or the agreement taken with any related agreement is unfair to the debtor because of one or more of the following. Now, that is distinguishing between two different situations, two different relationships. One is a relationship which arises only out of the credit agreement, and the other is a relationship which arises out of the credit agreement with any related agreement. And what the Court of Appeal's analysis in our respectful submission does is recognise that relationships can change over time, particularly when you can point to related agreements which started and ended, and the consequences of those related agreements have come to an end. So, my lords, I was just going through section 9 and the approach of the court to determine...
Take us to Central Electricity Board in Halifax.
Yes, yeah. Thank you.
I was just waiting for a page number.
Indeed, my lord. So it's 397.
Thank you.
And so this was, as you'll see, just reading the top of the head note, concerned Section 2 of the Limitation Act, which is the predecessor to Section 9. The following action shall not be brought after expiration of 6 years from the date on which the cause of action accrued. That is to say, and then actions to recover a sum recoverable by virtue of enactment other than a penalty or forfeiture by sum or by way of penalty or forfeiture. The relevant passage is Lord Guest at 418. it's the second paragraph down, which is in the context of a statutory claim that was being made in that case under, in fact, the Electricity Act 1947 for recovery of money. The test that your Lordship will be familiar with, the date when a cause of action accrues may be said to be the date on which the plaintiff will be able to issue a statement of claim capable of stating every existing fact which, if traversed, it will be necessary for the plaintiff to prove in order to support his right to a judgment. And Coburn and College is cited.
And his right to a judgment means presumably the whole of the judgment being claimed rather than some bit of it. I mean, take a case in which one's claim accrues because of payments made over a period of time.
Yes.
One's cause of action not complete just when the first payment's made, presumably, or is it a separate cause of action for each payment?
Well, indeed, my Lord, there would be a claim for each payment, yes. And so the cause of action to recover the payment necessarily requires the payment to have been made. And if there are a series of payments, then those series of payments must have occurred before you can sue for all of those payments. We cited the Bradford Old Bank and Sutcliffe decision in our written case, and that just simply is a judgment of Lord Justice Scotland, and we simply rely on it to say it expressly states that time starts to run for a plaintiff when they could first have brought their action. We do rely on the cases in paragraphs 32-34 of our written case, where we say they support the proposition that when interpreting a statutory claim, one ought to interpret the statute consistently with the policy of the Limitation Act, if that is possible, which we say it is in this case. Now, the two cases that we've cited are from disparate areas of the law. One is legal aid regulations, Rasool, and the other is wrongful trading, section 214. But the point is that across these disparate areas of law, the Court of Appeal in those cases sought to give effect to the policy of the Limitation Act when it construed those statutes, so as not to endorse delay and so as to give certainty to the parties' rights and obligations. And we've quoted the decision in Rasool. This was Lord Justice Ward. This is a paragraph, page 115 of our written case. Page 115. The purpose of the Limitation Act is to prevent delay, and we say that approach is appropriate to bear in mind when construing section 140A to see and what rights a consumer has. We also cite re Farmiser, which would be worth referring to, turning up, which is at page 550.
Would that be something we should look at after the short adjournment?
Indeed.